Okay, well, we're working some more here. We're looking at Chapter 4, Useful Definitions. Basically looking at the different motions that are filed, or what we call motion procedure in bankruptcy court. Frankly, when it comes to like arguing motions and things like that, that's where the attorney is important in the case. A lot of times they have to go get the word, they have to attend different meetings and so forth. Argue in front of the judge and this type thing. The paralegal can kind of keep track of the things in the office, work a lot with the debtor, and keep track of all the necessary paperwork and forms, prepare the necessary forms, and so in other words, you support the lawyer who is doing all the work in the courtroom. So basically, we'll look at the qualifications for debtors. And then look at some other provisions in the bankruptcy code. Okay, so basically notice and hearing involves the issue of what we call due process. So whenever we're involved in any kind of legal proceeding, there is an issue of due process. I've had many people over the years a little bit confused over what really is due process. I've even had some people say, well, due process is the process that's due. Well, my mother was an English teacher for 35 years. First thing she taught me when I was a little baby boy at my mama's knee is you can never define a term by using the term to define itself. And so this person was very self-important and thought they were pretty smart, but they said, well, it's the process that's due. Well, that's idiotic. Basically, the process that's due is descriptive. We're talking about a court hearing. We're talking about an impartial hearing officer. We're talking about the ability to call witnesses. We're talking about the ability to cross-examine witnesses. In some cases, the right to a jury trial. So in the bankruptcy court, the issue about due process, and here again, something significant that is going to come up when you're taking this class is the issue of what we call ex parte orders. Ex parte orders. Well, generally speaking, ex parte orders violate due process. Ex parte orders, by their nature, violates due process. And what do we mean by that? Well, every debtor, every creditor, everybody involved in a bankruptcy has a right to have a hearing on a lot of different things. So if someone files a motion, for example, then the court should not enter an order until everybody has given notice and the opportunity to be heard on these different issues. So that is what really complicates a bankruptcy petition in the United States because of the 14th Amendment. Basically, we have the Bill of Rights, for a reason, and that is, under the 14th Amendment, every American citizen is entitled to due process, okay? And so when we have that, nobody can lose their property or their life without due process of law, some kind of court hearing, okay? So in a lot of cases, they determine that an administrative type of hearing can suffice, and what that usually means is that there is no right to a jury. A right to a jury is only found where there's a substantial loss, like your life, that you have the right to a jury, or jail time, which is a form of taking your life away from you. You have no freedom to walk around. Okay, property, on the other hand, may not be as important, but if you're involved in, for example, a tort case where somebody hurt you with a car, you are entitled to a jury trial. So basically in bankruptcy then, you have certain rights. You have the right to have a hearing before they start taking money out of your check, for example. And so these are the kind of things. Ex parte orders, not favored in the law under any circumstance. So ex parte orders are not favored. So we'll see this on the discussion board And it's very important to comment on that. You know, show me that you understand that, okay, the judge may say, well, okay, you're sick, you can't show up for this hearing, then I'm going to give you an ex parte order to move the hearing date to a later date. But that's not saying that he's entered an order, you win, or anything like that. What he is saying is, well, extenuating circumstances will put this off, so they will sign an ex parte order in some of those cases that really do no harm to any of the parties. That's the important difference. So very important, always consider the due process implications of these motions. And the odds are, when you're looking at it, then the whole idea of ex parte orders is, shrinking. It's not very often, not very frequent. Important thing that comes up in your book and other things is, get your legal procedures correct. Make sure that your paperwork's correct, that all the T's are crossed, the commas are in there, the dots are on the I's, and the periods at the end of a sentence. Everything has to be just so. So very important. I see people turning in some of these petitions to me, and I want this to be as realistic as possible. So when you're learning how to do a bankruptcy petition, you're going to get it right. That we could take that bankruptcy petition, and I would be confident that I could file that in any bankruptcy court and they would approve it. We're not going to do that. This is just practice, but that's an example. Errors can be costly, is what your author is telling you. So very important. I've tried to stress this. Don't just slop anything down on that paper and expect that to fly. Here again, we're going back on and touching on this ex parte again. One of the words that come up is ministerial. So what that's saying is that if an ex parte order is granted, then it's only going to be for small issues like I described earlier. Okay, so it's not going to be determinative of the whole case. It's just something that can come up, small functions, changing dates because of unforeseen things, different things like that. So very little ex parte relief, which means no due process. So it's one side shows up in court, judge, will you sign this? Odds are no, he's not going to sign it. Evidentiary hearing, on the other hand, is just the opposite. This is the essence of due process. So evidentiary hearing is the essence of due process, okay? So what is an evidentiary hearing? Well, evidentiary sounds like both sides get to put on evidence, okay? Okay, evidentiary hearing, very important. In other words, both sides argue. Whoever brought the motion usually goes first. So the proponent of a motion goes first. Objector second. Okay? Now, sometimes they allow, another cut, which we call redirect, or even what we call re-argument. Okay, that's kind of rare because the judge has only got a short amount of time. I've seen cases in bankruptcy court where the whole case only is allowed 5 minutes for both sides. So each side, one side has 3, the other one has 2, or maybe 2 and 2, and then 1 for any closing comments to the proponent. Okay, so not a lot of time there. So what we think of as a trial, for example, is another form of an evidentiary hearing. Okay, so evidentiary hearing, type of a trial, kind of like a trial. The question is, who can be a debtor? Well, persons can be debtors. Well, this is a tricky answer. Person. You think a person, live, living being, right? Well, laws in many states say, in most of the United States, a corporation is considered a legal person. Legal person, okay? Some forms of partnerships can be legal persons, okay? So the person has to reside or be domiciled in the United States or have a place of business or some kind of property in the United States. So a corporation can be formed somewhere else, but it has to have some type of business connection with the United States to file bankruptcy in the United States. Okay, what chapters? This is important. I want you to write this down. And if you miss this, you don't have pencil and paper, come back and view this again. Chapter 7, okay, very important. These are definitions. Chapter 7, debtors can be individuals, corporations, partnerships, but not railroads, banks, or insurance companies. So I'm going to hit that again real quick. Okay, Chapter 7, debtors include individuals, corporations, or partnerships. But debtors in Chapter 7 do not include railroads, banks, or insurance companies. Okay? Chapter 9, the only debtors in Chapter 9 are municipalities. What do we mean by that? A city or a town. Something happens, they don't figure their taxes right, they don't get their bills paid, they get under the gun, maybe a bunch of people move away, something catastrophic happens like Hurricane Katrina, and the municipality just can't dig out of debt. And so basically it's very, very rare, but a municipality can file bankruptcy under Chapter 9. Chapter 11 debtors include anyone that could have filed under Chapter 7 plus railroads and some banks. Okay, Chapter 11 usually large debtor, lots of debt, lots of assets. So we're talking about the GMs, the Chryslers, people like that. Bear Stearns, number of these different big companies like that. Chapter 12 is the family farm. Remember that I told you about Chapter 12 is for family farms and family fishermen. Okay, very important. Very rare around here. You're not going to see a family fisherman very often, but we do see a lot of family farmers that get in a bind and have to file that farm bankruptcy under Chapter 12. Well, we've mentioned this before several times, but we'll bring it up one more time. The final one we're going to touch on here is Chapter 13. So Chapter 13 debtors are only individuals with regular income and less than a certain amount of specified debt. So it's in the millions, believe it or not, but it has to be under a certain amount of money that you can file a Chapter 13, which is a simplified type of reorganization called what we like to call a wage earner plan. Okay, if you've got too much debt and you make a lot of money, then you may be forced into a Chapter 11 as an individual, but that's pretty rare. Most of the people that are in this situation that we're going to see are going to fit under either Chapter 7 or Chapter 13. Once in a while we'll see a Chapter 12 with the family farm, but those are our main ones that we'll see on a regular basis. Once in a blue moon, we might get involved in a Chapter 11. Unless you're working for the very large firms in large cities like Indianapolis, Chicago, places like that where they deal maybe exclusively with corporations and are involved in these large-scale bankruptcies. So basically those are the main areas of the chapters of the Bankruptcy Code that we're concerned about. So each chapter involves a different kind of a debtor. Okay, well basically then we're going to look at Chapter 5 next, and that's where we're going to get into this whole issue of means testing. So we'll see you next time with Chapter 5 and means testing. Thanks for watching.